Hello and welcome. This is Legal Clinic. This is the program where we educate and enlighten you on your rights and the need to protect them. This program is made possible by the NTA Port Harcourt Network Center, FIDA Rivers State Branch, and Thav TV. This program will air every Sunday from 12:30 p.m. to 1 p.m. Please don't miss it. Stay on. When we come back from the short break, we'll be introducing our guests in the house today. We will do justice to a part of the Violence Against Persons Prohibition Law of Rivers State. Please stay on the line. We'll get this conversation started when we get back. We're glad you found time to join us on this program. Welcome back. To do justice to this topic on sections 1 of the Violence Against Persons Prohibition Law number 4 of Rivers State, we have a very, I'll call it an authority, somebody who has the facts, somebody who has been in the legal field. She was a one-time Assistant Secretary of FIDA Rivers State Branch, also a one-time Publicity Secretary of FIDA Rivers State Branch, and also a past chairperson of FIDA Rivers State Branch. You will agree with me that she has all the authority to speak on this topic. She's no other person but Mrs. Florence Itamunola. Ma, you're welcome.
Thank you.
Glad to have you here.
Thank you. It's a pleasure. Good day, viewers.
You're welcome, ma'am. Now we have, I have a like mind in the studio, and without wasting so much time and without much ado, we'll be hitting straight on this topic. So what we're going to be doing today is to do an analysis of the Violence Against Persons Prohibition Law. You may ask, people may ask, viewers may ask, what is the very interesting thing about the Violence Against Persons Law? Why the Violence Against Persons Prohibition Law? And what benefit is it to the average Rivers person or the average Nigerian in society? The Violence Against Persons Prohibition Law, like we said in our last episode, is a law that has come to give flesh, to again bring life to Section 36 of the Constitution of the Federal Republic of Nigeria, which embodies the rights, fundamental human rights of every individual in society. This law is here to help us, for us to be able to stand up for our rights, for us to be able to know those things that infringes on our rights as individuals, so we'll be able to speak up and get justice. And it's a very simplified law. It's not a law that is as bulky as the Constitution itself. It's a very simplified law which runs into few pages. And so in this, it's such a wide law, like I have said, but we have to bring it to your understanding. And to do this, we'll be taking them in sections. And on this particular episode of the program, we are going to be looking at sections 1 to 12 of the Violence Against Persons Prohibition Law, which is under Part 1 of the VAP law. Once again, Mrs. Itamunola, you're welcome.
Thank you.
Ma, please, we want you to do a quick rundown on the sections of this Part 1 of the VAP law. What is the law saying in Section 1, Section 2, down to 12, so that our viewers can have a first-hand information on what the law provides, the punishments, because it is very important for people to also know that you don't have to be a first-time offender or just the person who has carried out the offense. You would have contributed in one way or the other, or even saying or giving audience or even giving encouragement to the person who really committed that offense. So we want you to give an analysis of sections 1 to 12 of the VAP law to enable our viewers go home with something today.
Okay. Thank you.
Thank you very much, ma'am.
I want to start by appreciating the Rivers State government for coming up with this beautiful, enactment, adapting the national enactment for Rivers State. And I want to thank FIDA because one problem we have is laws being enacted. How many people know about these laws? So the need for sensitization is very important, and that's what FIDA is doing. So well done.
Thank you very much.
Yeah, the law, Section 2, starts with defining what rape is. And Section 2 has expanded the definition of rape. So rape is now defined, to mean where a person intentionally and without the consent of another penetrates, either the vagina, before it used to be just the vagina, but now the vagina, the anus, the mouth, or any other part of the body of that other person without the consent of that person. Yes, when someone does that, the person, for the purpose of gaining sexual knowledge of that person, when that is done, that person has committed the offense of rape. And now, we said without consent, a purported consent which is obtained by intimidation, by coercion, maybe by misrepresenting the nature of the act, or even like impersonating the spouse of a person and all that. It's not consent at all. Yes, so consent must be clear and not obtained by false fraud or any other means. That is seen in Section 2.1b. Then when we see Section 2.2, Section 2.2 tells us the penalty for this offense, and it is life imprisonment.
Straight. Life
imprisonment. But where a child is involved, where a minor is involved, what happens is that the process will be under the Child Rights Act. That it's what will take care of the child.
Okay, ma'am, let me quickly ask a question so our viewers will get a clearer understanding.
Yes.
You said when a minor is involved. Now, what is the role, what's the extent of the involvement of a minor? Is it as an offender or as one who is a victim of the offense?
No, an offender, a minor that commits what is this offense of rape, but is under 18.
So that means nobody is said to be a child for any offense?
No.
That means if a 14-year-old
commits, yes,
rapes or defies another, whether a minor or an adult, as the case may be,
yes,
there's still punishment.
Yes, there
for
is.
That 14-year-old.
Yes, there is. Not under the VAPAD, but under the Child Rights Act and the Children's Judicial Process. That will take, yes. Then you find out that one beautiful aspect of this legislation too is that under Section 2.3, a court is allowed to give any appropriate compensation, to the victim. Yes. Then also under Section 2.4, there is a register for offenders, and it is beautiful that some institutions have been empowered to keep this register, including the police, the Ministry of Justice, the Ministry of Social Welfare and Rehabilitation, and at least no more. It's not just with the police only. Different, yes. So which is very important. Then finally, also beautiful under Section 2 is that the public can have access
to that register. Wow.
Yes. So the names are there and anybody can go and access it and see. Then Section 3 talks of inflicting physical injury on another person, whether by means of a weapon, substance, or any other object. Substance can be acid, anything. That punishment is 5 years imprisonment or 500,000.
No negotiation.
No negotiation yet. And then there are also penalties for accessories before the act or accessories after the act or for attempts for such, maybe because of time, I will just be stating the principal penalties.
Okay,
so that
we know a lot of our viewers may not have a clear understanding of most of these legal terminologies.
Okay.
Okay, so we would like you to explain to our viewers what the word
accessory. Okay. When I say accessory before the act, these are people that aid the offender, they abet, they assist, they help in any form, they encourage the commission of that offense. But accessory after the fact are those that the act has taken place, but in one way or the other, maybe by way of trying to conceal it, trying to do any other thing to forestall maybe investigation, any other act done, to prevent investigation, to prevent prosecution, comes under accessories after the fact.
Okay, so that means in a case, for instance, like we used to know of female genital mutilation, the persons who holds the hands or holds the legs of the woman who, when she was being mutilated,
those are accessories before they were part of the act.
And then that act was done on that person without the person's consent.
Sure.
And so immediately after the act, for instance, the person wanted to go make a report. Now, the person who puts her inside the house locks the door and keeps the key so that she cannot, gain exit from that apartment and reach out for help. So that person is called an accessory after.
Yes, because the act had taken place.
Okay, thank you very much.
Thank you. Yes, let's go. So, section 3, we've talked of inflicting physical injury on another by means of weapon, object, or. Then section 4 talks of coercing another person to engage in an act that is physically or emotionally, psychologically detrimental to the person. And someone will say, how can you do that? What comes to mind readily is things done against widows, what we call widowhood practices. For example, you coerce a widow, take her inside, lock her up in a dark room, that she has to be there. That is detrimental psychologically and even physically, and even emotionally around to the person. So that is an offense under section 4 of the VAP Act. And there's also, in fact, for that act, it is 3 years with no option of fine. So it's a serious offense that you coerce a person to engage in any act or anything detrimental to the person's, psychological or physical health. So we must take note of that, and we must avoid such things. Yes. Then, section 5 talks of willfully placing a person in fear of physical injury. Somebody will wonder, they've just talked in section 3 about, willfully causing, inflicting physical injury. In this case, you are willfully placing a person in fear. Is different from section 3. That is, you might not have carried out that act, but everything you've done, you have caused the person to fear so much for his safety, for that fright, and yes. So that is also a serious offense, and it's 2 years imprisonment or a fine of 200,000. Of course, all these penalties take place upon conviction at the judge's discretion, whether it will be fine or imprisonment, depending on the circumstances of the case. Then section 6 talks of offensive conduct. An unoffensive conduct is when a person is compelled by another, by force or threat, to engage in any sexual activity or conduct that is also detrimental to the person's physical and psychological well-being. That is also, they are all very serious offenses, and such a person that commits such offense, if found guilty will be ready to go for 5 years imprisonment or 500,000 fine. Then we have section 7. It talks of frustrating investigation. You know, it's very common in our society. You know, someone has committed an offense, then with intent to defraud or to cover it up, to conceal that offense, you know, to try to conceal it, to frustrate it. How can this be done? For example, if there are documents that show the guilt of the person, for a person to maybe mutilate the document, destroy it, maybe in cases of rape, for example, maybe the dresses that we show the pants and all that, you burn them up or you hide them. Those things are offenses under the act, you know, and a person that does that, if convicted, will be ready to face 3 years imprisonment or 500,000 naira fine. So we must be careful about covering anyone, because for covering anyone after the act, we have defined accessories after the act. So please, all those are very important. The public should be aware. Don't be involved. Every good citizen should expose any wrong deed, not try to cover it. Yes.
Okay, ma, we will take a short break, and then when we come back, we will continue. Please stay on them and don't go away. Thank you.
Will you sit down?
Oh no! You don't have to suffer such indignation anymore. Don't give room for any form of violence or human rights violation. You deserve the right to protect your right, and you must know your right. So break the silence now. FIDA, NTA and Thav TV will make it resonate through the nooks and crannies of your community. So tune in to NTA Port Harcourt Network Center or Thav TV YouTube channel every Sunday at 12:30 p.m. Equip yourself on your rights. Legal Clinic, promoting your rights for a safer and saner society.
Welcome back, viewers. I hope you've been learning and following so far. So we'll go on with section 6 to 12 of the VAP law. And we still have Mrs. Florence Itamnola, Esquire, in the house to go on with this discussion. Thanks for staying on the line.
Okay, welcome back.
Thank you, ma'am.
Yeah, we're going to section 8 now. We just discussed section 7 before the break.
Oh, it was 7 we had done. I thought we had done 5.
Yes.
All right.
So section 8 talks about willfully making false statements. It could be orally before the court or in a written document.
And people do that a lot.
Very
without knowing
common.
that the gravity of the offense they are committing.
Very serious, yes. And then sometimes it's also like the document might be made with a view, you know, to tamper with the investigation or other things. So that is an offense. And
Under
also
section 7.
under section 8.
Section 8.
Yes, willfully making.
Yeah.
Then we have, this is very important to me, section 9. And I want the general public to understand this, that forceful ejection and denial of access of to a spouse into a house is a big crime.
And I guess this is most commonly committed by the male.
Every day, we see husbands throwing out their wives. Or a wife comes back, the door is locked, go back.
So where you're
you
coming
can't enter this house. And honestly, sometimes for 3 days, the children are there, suffering. The man is just feeling she should go. You know, there is a law against that. And please, I want to state it categorically too. It's not just for wives. Even a wife who does that to her husband
yes,
is equally guilty.
Of an offense.
You know, yes, of an offense. So we don't have that. No man, no wife, no husband can eject the partner or, deny access into their home. For any husband or wife that does that, the offense, if convicted, is 2 years imprisonment or 300,000 naira fine. But let me say this, the accessories, and that is common, in-laws, friends,
they'll come and help to
and
pack
all
the woman, and
that
then
help
all
to
pack the man out.
to pack either of the spouses, you are also guilty. And you too, we have 1 year imprisonment and 200,000 naira fine.
Okay, ma, I want to ask, is it possible for most of these offenses for the judge or the magistrate to decide that you will pay the fine? You will pay the fine and also serve the jail term?
Well, the way the law is couched, there are some areas where the law provided that either this penal imprisonment or this fine or both. So I guess it is in those cases that the judge can have the discretion to say both. That's my thinking. Because for others, they said either this or that.
Yes, because I also remember, if I'm not...
But let me say that for this, it is, for this section 9, it could be both. Yes,
that's what I was
it could be both.
Because the magistrates or the judge could be very, that's why I would say it's at the discretion of the court, could be very enraged and decide that this act, in fact, the punishment, the jail term or the imprisonment, your punishment is too minor for the pains and the trauma that person would have gone through.
Especially when there's so much impunity by some spouses. They don't care, they just do it, without regard to...
Some time ago, FIDA had a complaint of a woman who, the day the husband was to throw her out of the house, she was locked, she stayed indoors and the house was locked and everything. And they had to cut, the in-laws came, they had to cut the burglary proof, gain access into the house through the burglary proof, open the door and then threw her out of the house.
It's very unfortunate. That's why people must be sensitized. But apart from the sensitization, I think litigating the matter is very important.
Of course.
It's because maybe there haven't been several litigations, so there's still so much impunity. But we hope that as time goes on, there will be spouses that will be ready to come out to say litigate the matter and all that. Yes.
All right. Thank you, ma'am.
Thank you. So Section 10 is another area that it's commonly an area where many people offend against. It says depriving a person of his personal liberty. You can only do that in pursuance to a court order. But if there is no court order, and just like the case you are saying, a person is locked up, a woman or a husband is locked up in the house, it is an offense. The person should not be deprived. A person should not be deprived of his personal liberty. Then for that, you have 2 years imprisonment if convicted, or 500,000 naira fine. And it's the same thing, there are penalties for attempting the act, which is 1 year imprisonment or 200,000 naira fine. Then for accessory before the fact, it is 2 years imprisonment, 300,000 naira fine. For accessory after the act, it is 1 year and 100,000, 1 year imprisonment and 100,000 naira fine. Then Section 11 provides what to me appears to be amusing, but in reality, I have seen it happen. It's unbelievable. Section 11 talks about damage to property with intent to cause mischief or to just cause distress to the other party. I've seen it.
It happens
I've
a lot.
seen husbands who destroy a wife's property. They are even ready to burn certificates. And I've seen women who also just destroy all the valuable properties in the house. They pull down television. They pull down clock. Pull down.
Say they are angry.
They are angry. No.
Or you want to get at the man.
At the man. You want to get at the person. No. I'm happy that this has become a law. I mean, people that are married should be matured. Even a child should not do that. So they should know that there is a law against it, and there is a term of 2 years imprisonment if convicted, or a fine of 300,000 naira. And there are also for accessories and others, which is 100,000.
Let me ask, and also maybe chip in too, that it is not just destroying the personal properties. I think I've seen cases, because I know this law also has to do in one of the sections with spouses, like trying to force them financial dependence.
Yes, that's section 12.
Oh,
yes,
great. So
yes.
I was just coming.
Yes, that's
All
section 12.
Because that particular section, it found guilty, or it talks about trying to make somebody not to be able to work, to gain anything.
Yes.
And so we find out that when a woman is trying to get something to do, okay, since you don't want me to work, I start selling crayfish and small petty trade. And the man says, I think I've told you not to work.
Don't work.
And then he comes, he destroys
Scatters everything.
So
yes.
section 11.
Yes. Okay. Well, yes. Well, it's still damage to property, but then section 12 is specifically on forced financial dependence. You know, on forced or economic abuse. Yes. And if you go to section 40, is it 145, the definition section, it defines economic abuse specifically to include forced financial dependence. What does that mean? Just like you said, because you're a wife, sit down at home, don't do anything. No, you can't compel
and then
under this law.
Anytime I need money or anything,
you must come and meet me.
Seriously.
In fact, it also includes a working woman, for example. All your salary, bring it. You spend as if I wish. If I give you, if I don't give to you, you just,
A woman once came to the FIDA center and said the major cause of the problem between her and her husband was that the man was like, her salary should come to him. He would not dictate her.
Meanwhile, she doesn't know anything about his. No, it's not as if it's reciprocal.
And even he wasn't even doing anything. So I was not ready to do anything. And said, when she earns salary, she should bring the money
it because
to him.
It's the head.
It's the head of the home.
We see those things, but please, let the public know that there are laws that have outlawed those actions. And they have criminalized it.
The way they like.
Yes. And let's also say that economic abuse under the definition section also says it is a denial of inheritance right. Thank God that our Rivers State House of Assembly has also come up with that law, and the governor has also magnanimously signed it. So those laws are there. So denial of inheritance rights is an economic abuse because it deprives the woman from having assets that could help her. Then we have unreasonable deprivation of another of economic and financial resources.
Still under section 12.
Yes, under section 12. Okay. I'm defining economic abuse now. Okay. Because when you say economic abuse, many people might not understand what it is. But the the definition section defined it elaborately so that people understand what they are talking about. Okay. So you cannot destroy, that also comes under what you just said. You can't destroy her business or even household necessities and all those things. You are not permitted to do that. So the society should come of age. And whether you are an in-law, whether whoever you're a friend, cancel your people. Let's live right. Let's avoid all these acts of violence. That is why it is violence against persons prohibition law. So all acts of violence are discouraged by the law, whether against females or against males or against any persons. So
thank you very much, ma'am.
Thank you.
Viewers, I hope we have learned a lot from this. Thank you for joining us. We hope to come back next week with another exciting episode of this program. See you then. Thank you.